So we will start the AI intellectual property track with a talk by Nikola Kliska, the head of IP at Radonjanin Partners. Nikola is an accomplished attorney at law with a rich background in the legal services industry, particularly excelling in intellectual property and dispute resolution. Today he will give some legal insights regarding AI. So, Nikola.
Start with how you actually create AI system and how do you feed it. In order to create an AI system, you need data, and of course, it's hard for any company or any startup to create the data by itself and to feed it with the data that was created internally. In order to get a large amount of data, you need to take it from other companies or other entities. In order to make everything seem legal, you have to check who owns the previous works of art. And it's usually the previous works are usually protected by copyright. In that sense, we talk about texts, images, sound recordings, video recordings. When you want to obtain all these data, you need to get a proper license or to purchase all these sets of images or texts. But that can create a lot of difficulties for companies, and different jurisdictions made different solutions how to make everything easier. In the United States, we have fair use principle, and it was approved for a couple of times by the Supreme Court. So they say, if you're using previous artworks from other entities, you can use it freely if you're going to create something completely different. In some sense, OpenAI is using previous texts, and they are enabling outputs that are going to be completely different than what's put into the system. However, we saw that there are a couple of new court cases which show that companies are not satisfied with this principle in every aspect, especially those that are in the field of selling images. So Getty Images got really angry when they realized that DALL-E is scraping their data and scraping the work that Getty Images invested in for years and millions of dollars. And now they want to create a new portal for creating images, which is a competitor on the market. So they filed a lawsuit early this year. And there is another lawsuit filed in California this summer. It's a class action. This means that in the United States you have that option that you can file a claim which will benefit to a lot of individual claimants, and it's not covering just one person or just one company. In the European Union, we have different solution. You can use data of other parties. You can use images of other parties or texts under the data mining exception. It was regulated in 2019. And for example, Croatia already implemented that into the local legislation, Slovenia as well. What's the main point? You can use images or text or code of another company if it's for research or education, and that's easy. But when we come to the into the commercial field, you can also use it, but the companies owning that copyright protected work can opt out from the system. So in practice, they can say, you're not allowed to use data for example, from my web page. So you can put a disclaimer on your web page and say data scraping is not allowed. This was also implemented in the United States by OpenAI, who implemented technical measures to enable this. So they provided data crawling blockers. And for example, New York Times applied that. So it's not possible for OpenAI to scrape the data from the web page of New York Times. In the Balkans, we still have gray area. It's not clear how you can actually scrape the data from other companies and if it's legal or not. We can maybe talk about that later. But what I talked with Gaetano previously is that in the UK, you have similar situations. So you don't have these exceptions like in the European Union or explicitly like in the United States. The easiest way to use copyright protected work from other companies is, of course, when it's a copyright protected work that's not actually covered by copyright anymore because it's in public domain already. But that does not help a lot because you can use classical musical works or classical works of art in fields of paintings, for example, of Caravaggio, but that doesn't help, for example, in gaming industry. What we saw currently, what's happening in the gaming industry is that a lot of companies are actually using videos that are showing how the bodies of people are moving, how the hair is moving, how the grass is moving on the wind. And the systems are implementing that into the game itself. So designers do not have to think about all the aspects. And the players in the games will be more natural, and the surroundings around the players will be more natural in those games. We got a couple of inquiries in practice, and in some cases they try to build the data by themselves. So they made the footage and they recorded the natural surroundings, for example, the rain outside. But in some cases they had to buy the data from big corporations like Reuters because they have a lot of footage in their database. Once you build your AI system, it's important to protect it and to save it from your competitors, and that's the idea to get the benefit on the market. When we talk about new technologies, everybody think about patents, and it's important to say that it's hard for patents to be registered if they implement a computer code. Of course, that's not completely impossible. So if you have a system for image recognition and you have some physical device, for example, a camera which is taking images, and you have a system that puts those images in memory, and it analyze them and classify them, then you can apply for a patent. But what's the problem? The procedure lasts usually about 3 years at least, and you have to protect patent in each important or significant market. So the initial costs are around $100K or euros, and for startups that's hard to budget. Of course, big corporations are filing patent applications that are related to AI, so Sony, Samsung, Microsoft, of course, they are really active in this field. But where we can see the biggest benefit, it's copyright. So copyright is actually protecting your computer code, but it's important to understand how we lawyers see computer code. We see it as work of literature. We see it only as lines of code and lines of text, or O's and zeros and ones. If you are protected by copyright, it protects the code itself, but not the logic behind the code. So if your competitors want to use the same logic, they can use it, but they have to write a separate or new code. if during the creation of your AI system you create some databases, they also in Europe, they are individually protected. The content of the database is not protected by itself, but the effort that the creator of the database put into collecting all this data and classifying them is protected. And if you created such databases, you are allowed to prevent other companies to use them. And of course, you can also benefit from licensing, so you can license those databases. Trademarks, of course, if you want to put your product on the market, it's significant that you protect the name so other competitors cannot use the same or similar name. And we are also seeing more and more significance in application of trade secrets. So sometimes if you decide not to protect a patent, you can keep that logic behind your code and behind your system through trade secret or business secret. We are all used to signing NDAs, and everybody knows about non-disclosure agreements, but that's not enough usually. European Union made a big report on protection of trade secrets in European Union, and they analyzed more than 700 judgments that were passed in this field in the last couple of years. And what they saw that the courts are usually asking companies to show that they implemented special technological measures to protect their trade secrets. So if you're a company in tech, you have to also implement technical measures to keep your data away from your competitors. Trade secrets, we can maybe talk that during the panel, are also something that is currently shaking OpenAI. So they deployed the CEO on Friday, and then they returned him last night or this morning. We can hear various scenarios, but what's one of the stories is that they were afraid that they will start a new company and that he was preparing to start a new company, but because he owned all the information about how the company is functioning and how they organize their business model, is probably one of the reasons why they wanted him back. Now, maybe just to see how you can more easily organize your work. Of course, it's data auditing. It's important to check which data you are putting into your system. And what we saw in practice is that managers or product owners make a plan how to collect the data, but the developers themselves do not follow the rules, and sometimes they collect data which is not authorized by the owners. Of course, the safest way is to obtain a license, and sometimes it's useful for you to implement algorithmic controls like that crawling blockers, which will disable other companies to use your data. Of course, if you're starting a project, you probably know the local rules and you will know the rules for your market. But if you plan to set a project that will be present worldwide, it's significant to ask for legal support. We can see that in the case of OpenAI, they created a model that's not completely in line with the European GDPR rules, and they were banned temporarily in Italy for a couple of months until everything was resolved with the local authorities. So these are some of the advices we can share. And now I would leave microphone to Andrea to tell us how we can protect what is created by AI.
As a moderator, just to note that we'll have these 4 presentations, and afterwards we'll have a Q&A session on all of them. So please write down your questions. There'll be a lot of stuff around, so don't forget your questions. Thank you.
Thank you. So Okay, so you have your AI, you fed it with certain data set, you trained it how to perform certain tasks, and then as the end result, in case of generative AI, you get something, some new content. So what is it that you get on the outside of this process? Again, when we try to apply IP law and IP logic to the output side of this process, we hit a few problems, the same we do with the input data set. And this is what I'm going to be talking about today. So the key issues are: who owns the new data that was created? What is it actually that we get through generative AI? And then, is this new thing infringing upon earlier rights? Because we know that AI uses, in many cases, the copyright works of authors to produce this new data. So starting with the easiest of these three questions, let's talk about who owns the newly created content. Well, notionally, there are a couple of options. Obviously, the work is done by the AI. So does AI own the newly created work? Well, the answer to this is easy, because AI doesn't have a separate legal personality. It cannot really own anything. Is it the authors whose works were used to feed the AI? That would not be a very practical solution to give the ownership of the newly created work to them, because it could be easily be millions of people, and we don't specifically know whose work was used for the production of the actual end result. So then we're left with the choice between the AI developer or provider, and again here it can be different persons, because we can have one person who actually programmed the algorithm, and then another person who fed it with data. And as the other option, we have the end user or the prompter, so the person who is giving the instruction to the AI. And in most cases, we would turn to the terms and conditions to see what's written there. And in most of these terms and conditions that we've seen, the ownership of the new data is transferred to the end user. But when we say that, I mean, be aware of two things. First, terms and conditions can easily be changed in the future. So the situation that we have today can be changed. And secondly, having ownership over something sometimes may imply that you're also liable in case such data infringes upon somebody else's rights. And then talking about the second thing, which is what actually do we get when we use generative AI? Well, we know that what we get as an end product is something that we can recognize. It's either a text, or it's an image, or it's music, or video. So something that fits into the classic copyright categories that we are well aware of and used to operating with. But when we look at the process of creation, we already see that this doesn't really fit into the IP logic that we are used to working with. So IP law has always evolved, and it was created around the notions of creativity, innovation, and as such, these qualities are assigned to human beings. So, as Vladimir mentioned, animals cannot be creative in that sense. So even if you paint your dog's paws and let it walk around the canvas, or you give monkey a camera, what they create in the end is not going to attract copyright protection. And on the other hand, I mean, humans have always used technology in the past decades successfully to create art. But such use was merely use of technology as a tool. So the humans still had full control over the process. So it made no difference whether we are drawing something with a pen, or we are making an image in Photoshop or some other, through some other technology. But in this case, the entire creative process is completely shifted from the human to the machine. And in that sense, we're dealing with something unseen before. The human still instructs the machine, but we don't quite know what we're going to get through that process because the machine is autonomous in a certain way. So if you instruct Midjourney, for example, and you tell Midjourney, imagine a cat, you don't really know what you're gonna get. Is it gonna be an image of a kitten or an old cat? Is it gonna be black, white, gray, long fur, short fur, or so on? Obviously, the more specific instruction you get, the closer the end result is gonna be to your original idea. But there is still a great degree of uncertainty what you're gonna get. And then talking about creativity as such, that's an important notion which we need to understand talking about AI. Creativity obviously has a different meaning whether you ask this question from a philosophical perspective or psychological, linguistical, and so on. But in general, we understand creativity as innovative ideas and original ideas which the human has, and at the end of that process create some new value. And as the highest form of this creativity, we have transformational creativity, which means that you are imaginative beyond the existing structures and styles. So in the end, you create something really uniquely original, so a new style. Think of it as a new style in painting or music or whatever. And as such, human creativity is very much subjective. It's conditioned with our emotions, our past experiences, our mood, our environment, and so on. And it's very much impulsive. As opposed to that, we now have a completely different kind of creativity, which is not impulsive. It's not subjective, because the machine has no emotions. It doesn't care if it's raining today. It doesn't care if we had a fight with somebody the day before that. So it's very much objective kind of creativity, and also it's a very systematic kind of creativity because it relies on certain data to produce an expected result, although often the result comes up with certain unexpected way, let's say. So we already see that we cannot put an equation between the human and the machine creativity. And then we also need to examine the notion of authorship, which is a key requirement to talk about copyright work. And in Serbia, for example, we have the definition of copyright work as author's own original spiritual creation. And in EU, I mean, across the globe, we don't have a harmonized definition of copyright work, but most of these evolve around the notions of originality and expression of author's own personality. And bear in mind, originality in copyright doesn't mean that you create something new and novel. It just means that the work originates from the author. And when you look at it that way, it's clear that whatever was rendered and generated by the machine, it didn't really originate from the author, even though the author gave the initial instruction. So the answer to this question is pretty clear for now, that when we use AI, what we get as the end result does not attract protection through copyright laws. And this was actually confirmed recently in a case in the US. In the US, authors register their, unlike in Europe, they register their copyright works with the Copyright Office. And Copyright Office has consistently refused to register those works. And one of the artists who tried to register an AI-generated image actually challenged this decision before the federal court. But at the end of this process, the federal judge said, no, this cannot attract, and this is not a work of copyright, because human is the condition without which we cannot talk about copyright work. So without the significant involvement of humans in the creative process, we cannot get copyright on the output end of this process. But then already at that point, the judge said, but for the future, we need to consider which level of human involvement we require, because there might be some instances where, in the end, if the human involvement is sufficient, we might end up with the work of copyright. And then the final question is, what if what you created actually infringes upon the earlier rights of authors whose works were used for the training data set? Because we know that AI relies on this data to produce something new. So is the thing that is created substantially similar to earlier works. Some authors even say AI doesn't really create anything new, it simply mixes and mashes our works into something else. And there is also some ongoing litigation in the US. Maybe you also follow this in the news. A lot of authors, especially writers, are suing OpenAI, but also other AI providers for feeding the AI with their books. And among other things, they say also the works generated by AI is infringing upon our copyright. This new content is substantially similar to our works. But in a preliminary hearing, in one of these cases, the judge says, no, when I put a copy of your book next to the output of ChatGPT, I don't see any similarities. I'm not asking for a copy of your book. I'm not even asking for a substantial part of your book. And I don't see anything in the end result. So it seems that, at least for now, the prevailing opinion in the US, at least, is that this new output work that is created does not infringe in that way upon the earlier rights. And what happens if there is no obvious similarity, but the work is done in the style of a previous author? Again, in most cases, that would not constitute infringement, although the work that you are creating would not be very original, let's say. And but again, to avoid this kind of situation, if you ask ChatGPT to produce the work of a style of a certain author, it will refuse to do so, just to avoid this kind of situation where you end up with an infringing new work. And then what can you do as a user to address some of these issues? First of all, remember that for now, still, humans are still indispensable in this process. So the more involvement you can show, demonstrate, and achieve, the closer you can get to some kind of protection for whatever you created. Pay attention to the terms of use. Be sure that whatever you get as output really belongs to you. Secondly, you can also consider the fact that we don't have a unified definition of copyright work across the globe. Some countries even have the category of computer-generated work, which might potentially cover this situation. So maybe you want to look into jurisdictions where you're closer to meeting the threshold for copyright work. And then you can also consider alternatives modes of protection if you don't qualify for copyright protection, because copyright protection is not the only IP right or other type of right you can rely on. So you can think of trademarking the image you got, or you can think about trade secrets, like Nikola said. So there are alternatives that you can also consider. Thank you.